In the American system of government, the people are represented by three separate yet equally important branches. The legislators who make the laws, the executives who implement and enforce the laws, and the judges who apply the laws. Today, this will be one of their stories. You have in your packets some materials, as Kim said. You have Bart's article, Willowitching for Legislative Intent. You also have the Rehnquist Court Canons of Statutory Interpretation, and you also have the Court of Appeals decision in the case that we're about to discuss. What we've done here is to set up a practical problem. The presentation is going to be really broken into two parts. The factual scenario, what happened in the community, and then the journey of the statute through the branches, how this law came to be and how it came to be applied in this case. The point that I would like to make is that governing is a dynamic process. We each know our own branches the best, and so we tend to see the laws and the implementation of the laws through what we know best, through our own window. However, it's a dynamic process that not only involves our three branches of government, but of course involves the people who we represent. It involves them at the front end when they inspire laws and ask for laws to address certain issues. It involves them at the final end when they are in front of the courts and we are affecting their individual lives. And it is affected by that adversarial process that sometimes clarifies the law and sometimes changes the law. We are going to be very interactive today. We're going to use the PowerPoints to establish some structure, but what we really hope for is some good discussion and some input from you regarding your experiences, because we can all learn from one another. Bart?
It is my duty, of course, to similarly acknowledge the strong relationship the Idaho Legislature has enjoyed and continues to enjoy with our Supreme Court. That's a great testament to Patty Tobias, who has been there at least as long as I have been in the Senate, and of course our current Chief Justice who joins us today, as well as his predecessors. We value that relationship, and frankly we need that relationship. I should also, as a disclaimer, indicate that the things that I'm about to say are my own opinions, and some of the things I say, frankly, aren't my opinions, but in an effort to help us better understand what I hear from others in the legislative process and their interaction with the courts, I want to say out loud what sometimes isn't necessarily said out loud. When I was a student in college, I remember I had one political science class, professor. I didn't find it particularly interesting, and so I took more Shakespeare classes after that, not knowing what my future might hold. But I do remember that the definition that my political science professor made me memorize as a young freshman on the definition of politics, and it goes like this, and I can still, more than a week or two since I was in undergraduate school, recite it. And it goes, politics is the struggle of individuals or groups to secure their interest by seeking to influence those in authority. I'll say it one more time with your permission. Politics is the struggle, and that's my favorite word in the quote, of individuals or groups to secure their interest by seeking to influence those in authority. Well, politics is a struggle, and it's healthy. The legislature was created, and then other than Nebraska, there's a unicameral system, which I can't imagine living in that world, where we have to catch so many bad bills from the House in a given session, and occasionally we're grateful that they catch one or two of ours. But in the legislative process, it's created with two bodies. And then the designers of our system then turned them against each other. And so the Senate, as the session goes along, begins to be more frustrated with the House and the House with the Senate. I have been asked many times, how can you take so many people from the same communities and put them in two different bodies, and they're so different? It is my opinion that if you were to take 100 people and put a third in one group and two-thirds in another, you'd see that dynamic play out in almost every instance. It is my opinion and understanding that politics exists at the judiciary. I have friends who serve at appellate court positions who tell me that in an effort to reach consensus, they sometimes have to compromise on how they believe the law should read in the appellate decision. Well, that's a struggle. My experience teaches me, as I approach my 32nd wedding anniversary, that marriage and family relations are a struggle. There's politics in everything that we do. Well, Idaho is a citizen legislature, and there are very few professional legislatures throughout the country. And citizen legislatures generally do not have a lot of lawyers. Statistically, in my state, in the years I have been in the Senate, about 5% on average have been lawyers. When I was elected in 1998 to the Idaho State Senate, there was one other attorney. That is not atypical of a citizen legislature. They don't know how to lay a foundation for an expert witness. They don't understand the importance of appellate records and the importance of putting evidence into a record for appellate review. They don't even understand Marbury versus Madison. That's something they heard about, but have forgotten what it meant. I attended a CSG event not too many years ago in which I heard a governor ask somewhat rhetorically why the court didn't tell the legislature or governor that there was a known problem with a given bill. It was a significant bill. While they could have saved a great deal of time and effort and embarrassment if they'd just told us. A few years ago as well, I heard two seasoned Idaho legislators do the following. One campaigned, and in her campaign literature and public statements, she stated that it was her opinion that court opinions are advisory only and are not required to be followed. I heard another who was a lawyer who brought a bill to amend Idaho's Constitution to provide that Idaho Supreme Court decisions are not final until after legislative review. That's the world that I live in. When I was first elected to the Senate in 1998, my first session was in 1999, and I was frustrated. I'd spent more than a week or two in a courtroom. Witnesses were not sworn. Testimony was riddled with evidentiary problems. Bill's language was soft. We spent a lot of time amending bills and cleaning up old language. I wondered if I was cut out for this. So I went to the majority leader, who was the only other attorney. And I explained to him my frustration. I was really frustrated. Well, he listened and he related and he told me of a story of similar frustration when he was first elected to the Senate. He had been a young prosecutor in Ada County and decided that the laws of the state of Idaho needed to be reformed, so he ran for the legislature. And as he describes it, he had bills hanging out of every pocket. And he was running around, and in that element of frustration, he went to a senior member of the caucus and announced his frustration. And that senior senator took him over to the lunchroom, and he opened up the window, and he had him stick his head out the window, and he said, "Jim, what do you see?" And so he described the scenery and Capitol Boulevard and on and on. He says, "What else do you see?" He said, "Well, I see a picture of Governor Steunenberg," or not a picture, a statue of Governor Steunenberg. He says, "That's right. Idaho's been a state since 1890. And we've had a lot of wonderful legislators that have come and gone. And so far, we've only erected one statute, and that's to Governor Steunenberg, who had, by the way, to be blown up in order to have that statue erected for him. He told me the following. He said, "Bart, you need to remember that the legislative system is not necessarily designed for lawyers. There is a role for lawyers in the legislative process. You'll always be cleaning up legislation from prior years. It's not a lawyerly process," he said, "but it works." He said the legislative process is for good people to come and make laws. It's designed for farmers and teachers and doctors and engineers and businessmen. It's designed for those people. Lawyers have a role, but it's a narrow role. And in that process, we expect, once we pass our bills, for the courts to make good sense of them. And that takes us to our PowerPoint presentation.
I thought we'd just end there. Public events and public opinion. This first part is the factual scenario. These are events that actually happened, and you can imagine some public opinion that accompanied them. In July of 2006, the police were called to a fatal automobile accident. The driver, who was dead, was 20 years old, and he was drunk. The police traced an empty liter of rum to MP Liquors. MP Liquors was owned by a Vietnamese immigrant who had operated the liquor store and was supporting his family through that income for more than 25 years. The agency, the Liquor License Division, took action to revoke MP's liquor license. Now, it would also be good to say that the owner of the store, excuse me, the owner of the store is not the one who sold the liquor to the minor. It was one of the employees. MP said that the driver presented an ID. And the ID that was presented, everybody agreed, was the ID, the driver's license of the minor's brother. It was an out-of-state driver's license, and it was expired. Well, under the state statute, if a person is not 21 and exhibits fraudulent proof of age, then any action relying on that fraudulent proof of age cannot be used as grounds for revocation or suspension of any liquor license. So that's the law that was applied here. And so the issue was, is another person's expired out-of-state driver's license fraudulent proof of age? So I want to stop here for a minute and ask you, if you are, just with this scenario, if you are at this point unsure how to answer this question, is another person's expired out-of-state driver's license fraudulent proof of age? If you're unsure as how to answer that question, please raise your hand. Okay. Now, if you have some confidence as to how to answer it, whether the answer is yes or no, please raise your hand. Okay, so it appears that we have more people right now that believe that they do know the answer to this question. So now let's talk about the law enforcement process in the executive branch and the adversarial process that goes along with the law enforcement process. The agency has a regulation, and Regulation 47-912 says it is an affirmative defense if the minor presented false identification of the type listed in 47-912A. And that provision says a licensee may refuse to sell liquor to any person who is not able to produce adequate, currently valid identification of age. So now we have three terms: We have fraudulent proof of age. We have false identification. We have adequate, currently valid identification of age. So I want to ask the same question again. Those of you who are unsure of how to answer the fundamental question of is an expired out-of-state driver's license a defense in this case, fraudulent proof of age, raise your hand. Okay? And if you're still confident, raise your hand. Not much of a change. Here's the agency's ruling. Now this goes through a hearing at the agency, and an administrative judge makes this ruling. The judge says that the regulation says that the liquor store could refuse to sell to anyone not able to produce currently valid proof of age. The liquor store had posted a sign that said, must have valid driver's license and be 21 to purchase any alcohol beverage. The agency, the administrative law judge said the driver's ID was not adequate proof of age, but that it, excuse me, it was not adequate proof of age, but it was not fraudulent proof of age. If it was fraudulent proof of age, it would be a defense. But the administrative law judge says it's not fraudulent proof of age, and it is not adequate, and therefore the license may be revoked. And indeed, the administrative law judge did, excuse me, this was, it was not the administrative law judge that revoked it, but this then goes to the agency head, and the agency head then went ahead and took the recommendation and revoked the liquor store's license. So now we begin with that factual scenario, the journey through the branches. Where did this law come from? Where did these laws come from? Well, as we all know, laws typically start from constituents who have an interest or a concern, and they talk to their representatives, and the representatives make some judgments and begin to work on those concerns. And then they take them into the legislative process. Here's what it said in 1963. It is unlawful to sell liquor to any person under 21. It was an absolute rule. It was a rule that said, if you do it, we can take your liquor license. It was an absolute rule. There was really no defense to it, and there was no real explanation for it. Well, I gave it to him because he looked 40, or I gave it to him because he showed a 40-year-old ID. No defense. Times change. Back then, in 1963, it was unlawful to sell beer to any person under 18, but you could sell beer to a person who was 18. And so we also have changing circumstances in our environment, don't we, in our community and in our values.
And Congress tying transportation dollars to the standard of the sale of liquor.
And in 1980, this is still 1963, but of course in 1980 we have Mothers Against Drunk Driving, and suddenly the culture here changes, doesn't it? Dramatically. This was still in the years of the martini lunches. It was unlawful for the minor to buy beer by misrepresenting his or her age, and so the minor here also had some liability. And so then we come to 1973. In 1973, legislation is proposed. The legislation says that it is unlawful to knowingly sell liquor to any person under 21. And so that states what the violation is. The bill also said if a person who is not 21 exhibits normally accepted proof of age, which states that he or she is 21 or older, and the person to whom proof of age is exhibited has no reason or cause to believe that the person is less than 21, the liquor license holder shall not be in violation, it shall not constitute grounds for revocation of any license. So now we have the defense. We have the violation and the defense.
Judge, if I might here, and I want to interject right here because what I'm about to say is going to be disproved a little bit by some of the subsequent slides, and so I want to say what I want to say. Remember, to my friends on the bench, you have the advantage of 20/20 hindsight. To you it's foreseeable because it's happened. It's before you. And so it's easy for you to sit back and say to the legislature, you should have foreseen this. Well, the legislature doesn't have that full luxury. We bring our collective life experiences to the table and hope we get it right. We can't fully anticipate full application. Legislation is often written trying to hit one target, not thinking of the unintended consequences of some legislation. And now you're going to see that what I've just said in this particular instance was foreseeable.
So the rest of the story. So we have a Senate Judiciary Committee hearing, and the agency witness testifies. We need to modify what you have proposed. He's pointing particularly to the phrase knowingly. He says you can accomplish the same thing by striking the word knowingly and some other words. Senator C, we'll call him Senator Cole because that's what everybody else called him in 1973. So this just means a seller can accept anything, no matter how fake or fraudulent it may appear. So just present anything, and whether it's known to be false or not, the proprietor's off the hook. And the agency says, well, you'll never get a case anyhow. The license holder will always be at home in bed, a helper doing it, or somebody else checking it. This is the only way we can do it. We have been able to enforce against licensees who knowingly sell. But when they have a valid basis for saying it was a fraudulent ID, a good fake, a counterfeit, one that was extremely difficult to recognize, we never suspend or revoke. So now we go from the committee hearing to the floor debate. Senator Cole, looks to me like the seller is pretty well freed from of any restraints to sell to kids under 18. This is going to open the floodgates on sales to minors. Senator D, I won't give you his name because I can't pronounce it. Let's put the consequences on the kids who are copying the IDs. So went the Senate floor debate. It passed in the Senate as revised, as the original one that I showed you in the first place. Now we're in the House Judiciary Committee hearing. This eliminates the possibility of revocation resulting from fraudulent proof of age, and we've had lots of them, and they're very authentic looking and pretty easy to get hold of by these young'uns. Well, Representative H says, well, what incentive is there on the tavern owner not to serve? The agency says, under this bill, none. Anything that says a person is over 21 would be accepted. So Representative H says, true to what Bart was just saying, okay, so if someone has a library card with a date inaccurately stating the person is 21, then the tavern owner would not be liable. Is that what you're saying? And the agency rep says, yes, that's true. But we recommend that a licensees only accept a driver's license with a picture on it. Representative H, okay, let's suppose a guy showed up with a thing that said, my son John is 21, signed, his mother. That falls within this bill, doesn't it? Agency says, yes, it would. because we do not specify what ID is. Now, Representative A, with possibly a solution. Well, we could add a separate section that would read, the state licensing authority is hereby authorized to issue regulations providing specified types of identification. Representative S, the bill that came over from the Senate was very broad, and that any kind of ID took the tavern owner off the hook. This is an invitation to bad liquor dealers to rely on any ID. So the committee added a provision saying the agency could approve certain types of IDs.
If I might, Judge, just interject here.
You bet.
I know as a... first of all, I don't like this example for a variety of reasons. Number one, it's the House catching a mistake on the Senate side. And it does happen on occasion, and apparently did in Colorado. But I acknowledge that sometimes language is ambiguous when it leaves the legislature. But that ambiguity is not always unintended. Sometimes, frankly, that's what we have to do to get a bill passed. You've got competing political pressures that are being brought on you, and you are content to settle for language that's more vague to shut up some of the opposition and frustration. Otherwise, you're not going to get your legislation. Do we know and realize at the time that subsequent legislatures are going to have to tighten it up? Yes. Do we know and hope that there'll be administrative rules from time to time? Yes. Do we believe at the time that some of our judicial activist friends will help us clean up some of our ambiguity? Yes. We know all of those things. But I also, one of the things I do like about this is that it shows a lot of the legislative horse sense that some of these folks had. They could foresee some of the problems that existed there. They also could see that the knowingly standard was not the public policy that they as a state wanted to have. But what this also illustrates to me is that if the court is going to rely on this kind of a dialogue to interpret what the legislature intended, you are granting to loud-mouthed, over-debating legislators the right to modify or influence the definition of legislative intent. One of the worries that I have is that when I went to law school in the 1970s, the standard for the court's willingness to get involved in and even look at legislative intent was quite a bit different than it is today in 2008. If I look at my own state, for instance, in Idaho, prior to 1965, it is difficult to find any case in which they looked at legislative history at all. In my opinion, there is a difference between legislative history and legislative intent. But citing to these examples suggests that the history reflects the intent, and sometimes that will be true. It is my experience that that is not necessarily always true. Now, the law review article that we gave you is unique to my state. I admit it is. But I think that some of the principles that are contained in it do apply throughout the country. In the 1980s, that's when you see my home state's appellate decisions start to more aggressively use legislative history. And I realize that, and the judge has clearly illustrated by the raising of hands, that whether a statute is ambiguous or unclear is oftentimes in the eye of the beholder. You'll even find U.S. Supreme Court decisions where the justices cannot agree on even whether the statute's ambiguous or not. In my own state today, the standard is, quote, a statute need not be ambiguous in order for this court to examine the legislature's intent. That is not the standard I learned in 1970s. And I do not believe that my legislative buddies, my House members in my Senate, think that that is necessarily the standard. For me, I find it a little bit troubling. That's because I know how the sausage is made. I have sat in a lot of committee meetings where a given senator rambled on and on and on, and all the rest of us rolled our eyes. Won't he or she just shut up so we can get this bill out and on the floor? But when you on the bench get those minutes, all you have is that particular legislator's ramblings. You don't get the eye-rolling or the private conversations that reflect what you know I'm thinking. However, I should acknowledge that I'm usually that loudmouth legislator. If I could just briefly as an aside, this is not just troubling to me. Other states have struggled with this issue. Minnesota, I know we have representatives here. Minnesota have rules stating that floor debate is not admissible as legislative intent. But they also had a statute which sets out the parameters or factors that can be considered in divining legislative intent, quote, when the words of a law are not explicit. And in a Supreme Court case in 1987 in Minnesota, the Minnesota court said, listen, we got a statute that says we can. You got a rule that says we can't. Guess what? We're following the statute. And they looked at legislative intent. Connecticut. This is a more interesting example to me of what happened. The Supreme Court they had a joint legislative rule that said that the fiscal note and the analysis of the bill are not to be considered legislative intent. The Supreme Court had, in 2003, rejected the plain meaning threshold for statutory interpretation and said they could look at anything they wanted. So the legislature in Connecticut, and the Supreme Court adopted an all relevant sources standard. Then the Connecticut legislature adopted a new statute that says that they could only consider, quote, extra textual evidence of the meaning of the statute if you could show, and then they would adopt more of an ambiguous, unclear standard. And for the next several cases that came out of the Connecticut Supreme Court, they ignored the statute. Now, it is true that in a fairly recent decision, 2007 decision, that Connecticut does recognize that statute and has adopted a different standard. If you look at Virginia, North Carolina, additionally, they have provided more narrowing standards in which those legislatures are trying to say to the court, please be careful. What you think may be legislative intent is really nothing more than legislative history, and they're not the same thing. However, some states have taken different approaches. North Dakota and Pennsylvania have, in fact, aids in construction of ambiguous statutes in which both acknowledge that you can look at legislative intent or history, including, quote, contemporaneous legislative history. One last point on this before we go to the next slide, and that is the governor obviously signed this statute because otherwise the agencies couldn't take the action that they've taken. Are we going to see governors start doing more what we're seeing at the presidential level with signing statements? And if we do, are you as courts going to start taking signing statements as an expression of the collective bill process intent? You've looked at legislative intent, but that can't become law without either an override or the governor's signature. Can the governor, by a letter back to the pro tem or Senate president or speaker, say, I've signed this bill with the following understandings? And will that now become relevant to you as a court? Judge.
I think Bart's given us an excellent segue here into a broader discussion, even before we continue with the slides. Let me first say that I think it would be apparent to all of us that there was a constituency here that was concerned. The 1963 statute provided absolutely no defense. If a minor was served alcohol, then the agency could take whatever action it was going to take, including revocation or suspension, and somebody thought that needed to be changed. Now, whether it was the agency or whether it was the liquor store and tavern owners, we're only speculating. But it's likely that somebody in the community of citizens thought that some kind of provision needed to be made. And this provision probably arose in some measure by changes in technology. Suddenly the agency was talking about excellent counterfeits. These young'uns can get them anywhere. But what's the point for us here in this room? We need to communicate more. We need to become better educated on how one another goes about its business. The very things that Bart is saying, more judges need to know. The process of statutory interpretation and how judges interpret statutes, more legislators need to know. You have, as just an example in the handout, the Rehnquist Court's Canon of Statutory Construction. You will see, I will say first of all, that not all judges, in fact, probably few judges have ever read this particular version of the rules of the canons of construction. Not all courts and not all judges follow these the same. Nonetheless, what it does show is that over the years, the courts have developed various principled ways of looking at statutes and trying to understand statutes. Whether these are good or bad or the best or some are better is a matter of discussion among the bench now. The Antonin Scalia has put forward and started a wonderful dialogue about the role of statutory interpretation and how judges use it. You know, Bart and I went to law school in the last century, and at that time we were taught what we were taught about statutory interpretation. Antonin Scalia comes forward with some discussion of that and says, does this really make sense, some of the ways that judges are interpreting statutes, because exactly what Bart is saying sometimes does happen, that a judge or judges will say, well, we'll look at the statutory history and we look at what the loudmouth is saying up there and we say, well, there it is. That must be the intent of the entire legislator. Scalia says, you know, when you do this kind of thing, it's like looking out over the crowd and picking out your friends. You know, you look for the rule of statutory construction that serves your predisposition and you latch upon it. Judges must not do that. Too often we do, but we must not. We can look at the statutory history, and some judges might latch upon the loudmouth because they agree with the loudmouth, or they may realize that this is just discussion. There's even, at the highest levels of the federal government, lobbyists now who get involved in writing the committee reports, who get involved in writing the statutes, put the statements in these reports because they know that sooner or later the courts will come around to interpret these things, and if this is in there under the guise of a committee report, this will influence the courts when they eventually make their decision. In this regard, for the courts, purpose statements, when a statute has at the beginning a purpose statement, that is useful, that is helpful.
Oh, Judge. I'm here to tell you that the purpose statement, or statement of purpose as we call them in our state, are advertising. That's all they are. They are intended to minimize the bill. They are almost all described as, quote, housekeeping bills when they are significant public policy shifts. They are not even worthy of being called prologue or preambles. They are, for whatever value that is, that's my opinion of those. They are oftentimes written by the bill's sponsor with an eye on passage, not an eye on judicial interpretation. That's what they're trying to do.
And this is why we need the dialogue. This is why we need the dialogue, because as judges, we look at that, and we look at that as being the statement that was voted on and approved by the entire legislature, and it reflects their common purpose.
Well, in our state, Judge, bills are voted on, titles are corrected, statements of purpose are attached. That's all they are. I don't vote on a statement of purpose. I even have rules that say that committees are supposed to make sure they're accurate. Oh yeah, they add that to their list of things that they don't do. But I vote on a bill. Titles are corrected, statements of purpose are attached.
And again, the point is, if the judges are seeing this statement of purpose in Idaho, and they don't know that, and they're relying on it, then they're making a mistake, I suppose. I mean, we have some Idaho judges here, so I can't say whether they're making mistakes. But the point is,
they never make mistakes.
Look at what we're uncovering just in the course of this discussion. I'm saying things about how judges view what legislators do. Here's a legislator saying something that at least I didn't know, and maybe other judges didn't know, that they don't vote on statements of purpose. This is why we need more interaction. This is why we need more communication. This is why we need more training. So now let me just pause here and say to the audience, based on this discussion we've had just now, what are your reactions? What are your thoughts about this? What are your experiences? Dan.
I'm worried about the poor guy that's about to lose his license. We already impose a high burden that you must know everything in the published statutes. Does a citizen have to know the history? I mean, why are justices trying to define legislative intent from a history that's not available to the public?
We did not. That's not how we decided this case. For the purposes of our discussion, I wanted to go through this. The way this case was decided was not on that basis. No? Well, wait and see. Wait and see. Right after this commercial.
Is this on?
Yeah.
As a legislator and also as a practicing attorney, I've frequently had to go back and look at the legislative history on things to find out why did the previous legislature do something if I could determine it. And I think it's true, as Senator Davis said, that in the 60s and earlier you find very little in the legislative, or that's in the court decisions that refer to legislative history. And I think the reason for that is the increase in our technology. I've gone back and looked at legislative history from the 70s and earlier, and there's virtually nothing there other than what happened is the end result. But as our technology has improved, we've come to the point now where we have the files on our legislative history are becoming voluminous. All of the good lobbyists bring written testimony and make sure it gets inserted into the record. And I've seen the court opinions that quote what lobbyists have said as to what they thought the bill was intended to do. And so now we've reached the point where we can take that testimony and digitize it, print it out, and do word searches, and you can find all of the legislative history instantly, practically down to the last word. So I think a lot of this has to do with technology.
I would add to that, I couldn't agree more with what you have just indicated, but I think there's another component to it as well, and that is the idea of open meetings became more common about the same time period we see the courts beginning to use legislative history. it is my understanding that a lot of the current open meeting laws were as a result of events that happened in the late 60s and through the early part of the 1970s. Well, that's not uncommon. In my own state, you were not even allowed to attend a committee hearing without the permission of the Senate President Pro Tem or the Speaker through the 1950s. They were closed. So you don't have the benefit of those committee hearings and the history that went with it. And the minutes were basically committee reports were we send the bill out with the recommendation that it do pass. And so I would just add that to it. Now, don't get me wrong. The very first case I tried in federal court, I won because I used a quote from a member of Congress that said this is what it meant. I have since learned that that congressman was wrong, but it helped that day.
Okay, wait a minute. All right, so here's what comes out of the House as they fix what the Senate was doing. The state licensing authority is hereby authorized to issue regulations approving specified types of identification. It shall be a defense to any action for sale to a minor if the minor presented identification approved by the department for the purpose of proving age. So let me ask you the question again. Back to the question, this question is a little misleading because now we have some authority to the agency, but this was the statute. Is another person's expired driver's license fraudulent proof of age? Those who are still unsure or those who have become unsure? Okay, and those who are still confident that they know what this is? Not much change. Rulemaking in the agency. So now we've moved from the community where the law was applied and the agency where the law was applied to this liquor store owner, and then to the statutory process, the legislative process, and now we're in the agency. And here the legislature has given the agency authority to, as it says, issue regulations approving specified types of identification. Now, how do they go about doing this? When they, in Colorado, when they want to make a regulation or a rule, they publish notice. And they conduct a public hearing. And they submit it to the Attorney General for review. And they publish the rule. And so in 1974, with the authorization of the legislature, Regulation 16, licensees may refuse to sell beer to any person not able to produce adequate identification of age. The kind and type of identification deemed adequate shall be limited to Colorado operator's license, out-of-state operator's license, military ID, valid passport. The word valid becomes more important later. Now, just to make things easier, in 1976, we changed the regulation number, so we make it harder to find, I suppose. Regulation 16 becomes 47-128.3. And, of course, there is a 128.3a. The kind and type of identification deemed adequate shall be limited to these. But the word valid's not in front of passport anymore. In 1977, the regulation is further amended to say licensees may refuse to sell any alcoholic beverage to a person not able to produce adequate, currently valid identification of age. And then in 2001, the regulation reiterates the defense. And it says, it shall be an affirmative defense if the minor presented fraudulent identification. Now, the agency doesn't say fraudulent proof of age. Now, they're saying fraudulent identification. Not only that, but it has to be of the type established in Section A. And the licensee possessed an identification book containing a sample of the kind of ID presented by the minor. Why is that? Because what we're looking for here is valid identifications. We're looking at, if you're talking about a state driver's license, then what does a state driver's license look like? We don't want the kid to go on to his his Mac or his PC and create something that isn't even close to what a Michigan driver's license looks like and get past the liquor store owner. So the liquor store owner now has to have a book that he can compare the identification to see at least if it's the form and the valid as to form. But this is still the issue. Now, I use due process in this sense with the small d and small p for the lawyers and judges in the room, but the applying the law in the courts. So now we are at the point that the agency has revoked the liquor store's license, and he has appealed to the court. The agency ruling that is being reviewed is, as I said before, that the liquor store owner could refuse to sell to this person because they didn't have currently valid proof of age. He had posted a sign that said you have to have a valid driver's license. Driver's license, according to the agency, was not adequate proof of age under the regulation, but it was not fraudulent under the statute. Now, we get to something that most citizens have no idea about, and that is, what is the standard of review in the appellate process? Frankly, far too many lawyers don't know this part of lawyering. What is it that when the court, that an appeals court looks at the trial, that it may do and may not do, that it may decide and may not decide? Most citizens don't realize that the facts are decided in the trial, in the courtroom. That's the crucible to determine what happened and what did not happen. And appellate courts do not decide the facts. We do not hear witnesses. We do not decide what happened or did not happen. What we decide fundamentally is whether the process of the trial or the hearing was in accordance with law so that this person received a fair hearing under the law. And I can tell you that often enough the appellate court may not agree with the outcome below. That often enough an appeals judge will be voting in a way that is contrary to his or her heart, in the sense of whether this person, whether that judge at the appeal level would have ruled the same way at the trial level with regard to certain discretionary matters usually. So the standard of review of this agency action is whether the agency acted in an arbitrary or capricious manner. Whether the determination of the agency was or was not supported by the evidence. Whether the agency exceeded its constitutional or statutory authority. This is the basis for the review by the Court of Appeals. It seems, back to Dan's question, at the appellate level, we are pretty far away now from the justice of this liquor store owner and this process, and yet we are a part of that justice process. Now, the task typically in interpreting statutes is to give effect to the intent of the legislature. We look at the plain and ordinary meaning of the words, and we seek to give effect to the intent of the legislature as reflected in those words. And as Dan says, and this is another point that Justice Scalia makes, it is the words that put the individual citizen on notice, not what was in the hearts and minds of the legislators, not what the big mouth said at the hearing, but it is the words of the statute or the regulation that let a person know how they can act. And after all, that is a part of our system, isn't it? To give citizens a way of conforming their conduct in a way so that they can succeed in their endeavors and not face consequences in the courts. We want predictability for our citizens when they seek to conform to the law.
Well, Judge, if I could just briefly interject here. This is an area where legislatures need to pick up their game. I don't mean just in wordsmithing. Those, obviously, the first way to express it is in what we wrote and what we passed and what you're looking at. But do we collectively, as a House and a Senate, have a way to better say to you, look, these are reliable sources, and these are unreliable sources. The legislative process, by definition, is the art of the possible. It is, in fact, a compromising process. In my opinion, sometimes you can learn more about what the intent of the bill is by looking at a minority report than you can at any committee report that I've seen throughout the country. Because the minority report tells you what the bill isn't. And you can use that to then perhaps better define what the bill is, or what the intent of the majority appears to be. Because the minority report isn't limited to coming from people of the minority party, but from those individuals who are the minority on that given bill. In Idaho, we sometimes will spread legislative intent on the pages of the journal. But if we print and spread that legislative intent over the Senate journal pages, and it's not over the House journal, does that mean that the Senate intended something different than the House? Sometimes that legislative intent is actually stated in preambles or introductory sections of the statute. I acknowledge that the issues and policy issues that we have to wrestle with are very hard, and we get to vote our heart. But the reality of it is our hearts are split. And I don't get to vote 80% aye and 20% nay. I only get to vote aye or nay. It's the sum of those votes. It's the sum of the collective wisdom that gives you the statute that you have to wrestle with. There is also the herd mentality in politics. I'm sure you never have seen that in your own state, but I watched it with interest last night as we all went to dinner. If collectively a large group was going one way, the herd followed. And that's true in the legislature. If you start voting and you look up there and you see the herd's going in a different direction, there's safety politically in numbers. You know what? Yes, I voted that way, but my goodness, so did everybody else. But that not necessarily fully reflect the difficulties that we wrestle with. One last point on this, and that is, if you were the trial court judge and you were being asked to allow this kind of testimony in as parole evidence to further define a contract, do you think that we've laid an adequate foundation for this to come in? And I don't think you would say yes. Then why, at an appellate level, do you find it to be so valuable and so guiding? He asks rhetorically.
And he responds that we didn't. He responds that what's being shown here is something to show all of us the process, the journey of a statute through all three of our branches. The opinion that was written, that I wrote, at the appellate level, whether you agree with it or not, is based on this standard of review of what the agency did. And if you notice, one of the questions is whether the agency exceeded its statutory authority. And its agency's statutory authority appears here. The state licensing authority is hereby authorized to issue regulations approving specified types of identification. It shall be a defense to any action for sale to a minor if the minor presented identification approved by the department for the purposes of proving his age. This is the statutory authority upon which the agency took its action. This is the statutory authority upon which the agency promulgated its regulations. Now, the history that I've given you about the back and forth is to basically let us see how this came about. But it is not what drove the decision. Okay, so when we do statutory interpretation, I think it's important for legislators to know that when we do that, we seek to give the effect to the plain and ambiguous meaning of the words. We apply standard rules of grammar and syntax. Sometimes even the placement of a comma can change the meaning of a passage. We try to read the words in context. We don't try to isolate on one word when we're doing it right. We try not to isolate on one word. We look at the entire statute and try to understand this phrase, this section, in the context of the entire statute and what the statute's trying to achieve. And we try to make it so that no one part is inconsistent with the rest of the statute. We want the statute to operate effectively as a whole. When words are ambiguous, we can look to legislative intent. We can try to figure it out. We reject illogical or absurd interpretations. We assume that the legislature does not intend to be absurd. But of course,
That's one of my favorite assumptions.
right, yeah.
Because the odds of that, of us never being absurd or illogical.
Well, and frankly, absurdity to some, hopefully we would all have a similar sense, common sense, of what is absurd or not. But certainly it is possible that some of us would look at it as absurd and some would not. Now, at the risk of, again, changing our focus, because my point here has been to carry us through the actions of the legislative branch under our federal Constitution, Article 1, the first branch, and then Article 2, the second branch, the executive branch, and eventually Article 3, the third branch, which is the judiciary. We give deference to agency interpretation. We give them deference in part because they were involved in the legislative process here, for example. We give them deference because they are working day to day in the real world of liquor licenses. And we try to discern it from legislative history, and as we've all seen here, that's a trick. Not intended to be a nasty trick. So, what are the applicable terms here? We have a statutory term, fraudulent proof of age. We have a regulatory term with authority from the legislature, false identification, adequate, currently valid identification of age. And so the questions I ask now, fraudulent proof of age, does that include any document regardless of the source or obvious invalidity, that is presented for the purpose of attesting to the age of the presenter and is false or fraudulent for that purpose. This is my son John, a picture of whom is at the right. He is 21. He was born on such and such a date, signed by his mom, which was one of the legislators said. Is that fraudulent proof of age sufficient to allow the liquor store owner to sell liquor to the person without liability for losing his liquor license? Is it any document that, regardless of the source or obvious invalidity, is presented for the purpose of identifying the presenter and is false or fraudulent for that purpose? Can the minor bring in a picture of his mother on his mother's ID card and say, this is my ID? The liquor store owner says, well, I'll serve you liquor. And then later when the agency comes, well, he says, well, it was fraudulent proof of age. He showed me a picture ID and said it was him, and it wasn't him. Is that good for the defense? Valid as to what? When the agency says currently valid, what are they saying? Are they saying valid as to the age and identity of the presenter? Well, that's ridiculous, because then there would never be a defense, because whenever it is valid as to the age, I'm 21, valid as to my identity, this is me, if it's truthful as to those things, there's no violation. Does it mean valid as to form? Does it mean valid as in currently valid, not expired? Adequate, currently valid identification of age. Does that mean any document of the types listed in the regulation that is presented for the purpose of identifying the presenter and identifying his or her age, attesting to his or her age, and is false or fraudulent for that purpose? And so that brings us to the end of the slides. It does not necessarily bring us to the end of Bart's comments. Bart, got any other thoughts?
Yeah, I do. But I promise I'm about out. When I hadn't been in the Senate very long, and before I was in leadership, I was sitting back and I watched a senior senator who was presenting a bill that was really important to him. He was a passionate person and a good man. But he was struggling to present his bill on the floor because his opponents were picking apart the bill by looking at the words. And in closing debate, he said, look, this is my intent. And then he stated his intent. The bill is just words. And the bill passed. What the judge has just illustrated to us is what the courts do with the words and not the intent. Sometimes they lean too heavily against our intent. But as legislators, they do this kind of analytical review of the words that we give them. And we have got to find a way through the legislative process to give them a better set of words that more accurately reflect the collective intent of our House and our Senate. Thank you.